Welcome. We are visiting the basic structure values of the Constitution of India. This aspect we had taken up in between when initially we are visiting the trial proceedings steps. Our initial focus was upon the procedural steps. Then in between we had an idea that let us have glimpse of the substantive justice. This has taken us to the Constitution. From there, we have been to the basic structures values. Now let us revisit the trial procedures. Now in the trials, some situations arise in between. Trial, say, had initiated with the opening of the case by the prosecutor, then consideration about the charge, and then there will be an evidence. In all these situations, there will be many in-between situations in respect of which one may feel like that the procedure is not being regular or proceedings are not having correct format, or that there are illegalities, or there are illegalities of the nature that correction is required. The procedural track deserves to be halted, deserves to be reversed, deserves to be put on a different format. For all these situations, the Code of Criminal Procedure has the provisions for reference and revision as well as for appeal. There are three distinct steps. One step is of a reference, other step is of a revision, another step is of an appeal. Today, we will be focusing upon reference and revision aspects. These provisions are Chapter 30 of the Code of Criminal Procedure. Of these, there are Sections 395 to 405. These 11 sections are providing the format of procedural steps to have a reference and to have a revision. Section 395 says reference to High Court. There are situations, we will read it, that in which the trial court may refer the matter to the High Court for having the answer for the legal situations in which the trial or proceedings may have been held up. Then it is a disposal of the case according to the decisions of the High Court is provided, calling for records to exercise powers of revision, power to order inquiry, power of additional session judges, High Court's powers of revision, power of High Court to withdraw or transfer the revision cases, option of the court to hear parties, statement by Metropolitan Magistrate of ground of a decision to be considered by High Court, and High Court's order to be certified to lower court. These all are the set of provisions which are of great practical importance, because every trial impliedly would mean reaching at a substantive justice. In between, the procedure may reach a stage where there may be reflection upon the ultimate goal of reaching at the substantive justice. Now, let us be through these provisions. Of these, Section 395 and Section 397 on the one hand, and the power of the High Court in different situations. But we will be now taking up only two sections, Section 395 and Section 397. Section 395 provides that, let us read it, where any court is satisfied that a case pending before it involves a question as to the validity of any act, ordinance, or regulation of any provision contained in an act, ordinance, or regulation, the determination of which is necessary for the disposal of the case, and is of the opinion that such act, ordinance, regulation, or provision is invalid or inoperative, but he has not been so declared by the High Court, to which that court is subordinate, or by the Supreme Court. The court shall state a case, setting out its opinion and the reasons therefore, and refer the same to the decision of the High Court. See, essentially it is being taken that the trial courts are courts of facts, and on the basis of certain facts, certain decisions are to be reached at. However, in all this real setup, situations will be that there are certain acts, certain ordinances, certain regulations with respect to whose interpretation or whose validity a situation will arise, that there is a need that first of all those questions be determined. The trial court is not within its powers to interpret those or decide for themselves, and the matter can be referred to the High Court. It is this reference which is a very big provision, and it is this provision which is to be utilized, it is to be availed, and references are to be made to the High Court by the trial court. So we, as lawyers, as counsel of the parties, as a such, can make a request to the court to make a reference. Power is with the trial court, but the party to litigation may impress upon the trial court, submit with the trial court, make a request with the trial court that in such and such situations there is a necessity that reference is to be made to the High Court. Now, the explanation attached with this provision is very important. As it is here, it is explained. It is explained in this section. Regulation means any regulation as defined in the General Clauses Act 1897 or in the General Clauses Act of a state. A court of session or a metropolitan magistrate may, if he thinks fit, in any case pending before it or him to which the provisions of subsection 1 do not apply, refer for the decision of the High Court any question of law arising in the hearing of such case. Now, question of law arising in such hearing is the important clause here. When a party will be requesting the court for making a reference, then the party is to explain to the court as to how here such situation has arisen. Now, if the party wants to impress upon the court for such reference, then in the pleadings it is to be made specific as to what precisely is the question of law with respect to which a reference is to be made to the High Court. So that question of law is to be precisely framed, and then in the context of the same, the request may be made. The third part is any court making a reference to the High Court under subsection 1, subsection 2 may, pending the decision of the High Court thereon, either commit the accused to jail or release him on bail to appear when called upon. So one eventuality that once if the accused is in a custody and the matter stands referred to the High Court, presumably a reasonable time will be taken by the High Court to determine that reference. So in between, the accused may be released to a bail or can be sent to a jail. Therefore, while the accused is in custody, then the counsel has to make a specific request for bail, or even written bail application may be required to be filed. Therefore, while we are in before the court in reference to the proceedings under Section 395, then there are two situations arise. Number one, that we may make a request in writing to impress upon the court to refer the particular specific question of law for determination by the High Court under the reference by the trial court. The second will be that we have to file a petition, oral or in writing, for the bail of the accused. It is in this context that this section deserves to be read from the practical relief point of view. Then Section 397 is most frequently invoked section. This section is titled Calling for Record to Exercise Powers of Revision. Now, it is not a revision petition as such, it is being said. Calling for records to exercise power of revision. Let us first be through the text. The High Court or any sessions judge may call for and examine the record of any proceeding before any inferior criminal court situate within its or its local jurisdiction for the purpose of. The High Court or session judge may call for an exam for and examine the record. Why? It is for the purpose of satisfying itself. The record is to be called by the High Court or the session judge to examine for the purpose of satisfying itself or himself to the which aspects satisfaction is to be made, to the correctness. First word is a correctness, second is legality, third is propriety of any finding, sentence or order recorded or passed, and as to the regularity of any proceeding. You see, there are four words or four situations being visualized under Section 397. The first is correctness, second is legality, third is propriety of the finding, and the fourth is regularity of the proceedings. So, this section is a very wide section. It is basically a full, complete regulatory provision over the trial courts. The trial courts are to conduct the trials as per the procedure established by law. We had initiated discussion on these aspects, beginning with Article 21 of the Constitution of India, where it has been provided that liberty and life cannot be deprived except by the procedure established by law. Now, that aspect that it can be deprived only by procedure established by law. Therefore, in that context, we have to be through these four distinct aspects or four distinct situations in which record can be called for. Insistence is upon calling for the records. Why? The satisfaction is required that liberty or life is not to be deprived except in accordance with the procedure established by law. Therefore, the procedure, it is not only final finding or judgment, it is the procedure, it is in steps in which that result is reached at. Therefore, it is the correctness, it is the legality, it is the propriety, and it is the regularity. Now, these four words as such be tabulated and one shall reach at a full expression about their meanings, interpretations. Now, correctness is the word which has its dictionary meanings. Legality is the word which also has its dictionary meaning. Propriety is also a word which has distinct meanings and features. And regularity is also a word which has its distinct meanings. So we have to distinguish, and let us pose to ourselves that during the trial, case stands adjourned. Simple adjournment is there. What type of tests, yardsticks, standards are to be applied to see whether it is correct order, whether it is legal order, whether it is a proper order, whether it is a regular order. So regularity, propriety, legality, and correctness, these four adjectives are for these technical terms, are for these reservoirs of values with respect to the procedure for the trial, which may result into the curtailment of liberty or some deprivation of the life. So deprivation of life, curtailment of liberty during the procedure, during the trial procedure is a very big concern. Law has taken note of it. Legislature has provided a procedure and also a supervisory provision. Section 397 as such in common parlance is being taken a revision powers, a source of powers, authority under which party may come for a revision. Now, but title given here is calling for records to exercise power of revision. So, to exercise power of a revision will be ultimately not only with respect to the legality of an order, it is with respect to propriety of the proceedings as well and findings as well. It is also with respect to the correctness, and it is also with respect to regularity of the proceedings. So regularity of the proceedings and correctness of the proceedings are the aspects with respect to which, with time, we have made ourselves insensitive. The sensitivity with respect to the regularity of the proceedings and correctness of the proceedings as such stands sacrificed. Therefore, we firstly, as scholars, have to analyze it, why it is happening and how it can be put back on the track. Then, as a students of law, we have to appreciate the distinctive features and values of correctness of proceedings, legality of proceedings, propriety of proceedings, and regularity of proceedings. And as lawyers, we also have to be very sensitive to see that during the procedure of the trials. During the steps of the trial, the sacrifice is not expected with respect to the liberty or dignity of the person on a trial. Every person on trial is innocent till he is convicted. But these are the stages of trial prior to the findings. So, prior to the findings, what are the rights of the accused? What are the rights of the parties? It is with respect to that we have to think, we have to visit this section 397. So, while we have a focus upon the revision petitions, we shall mention the petition under 397 and for calling of the record to exercise power of revision. This power of revision is not only with respect to the illegality, this power of revision is with respect to the correctness, with respect to the propriety, and with respect to the regularity of the proceedings as well. So, let us be conscious enough, let us be sensitive enough, let us be alive to these statutory provisions. The expectation of law, the expectation of the procedure is that there will be regularity of the proceedings, there will be correctness of proceedings, there will be legality of the proceedings, and there will be propriety of the findings, sentence or order, recorded or passed. Therefore, this petition under 397 is to be titled calling for record to exercise power of revision with respect to the legality, correctness, regularity. Therefore, the responsibility upon us to see that we have properly sensitive justice delivery system, then we have to intervene. We must step in at each and every stage where there is a deviation from correctness or legality or propriety or regularity of the proceedings. Now, theoretically, it looks sound, it looks very good, it looks blissful, but in practice, the situation, when it's considered in terms of the time consumed, the expenses, and other connected aspects. So we have to consider, we have to think, we have to balance, and it is for it that I impress that let us be through at least 10 to 15 judgments of a particular high court only, and then reach at the index of the sensitivity with which these provisions are in force at present in reality. Thank you very much.
Thank you, sir.